Hello, everyone. Joshua Gilliland here with Howard Reissner, CEO of Planet Data, and we're going to talk about trends across 2014 in electronic discovery. Howard, how are you today?
Very well. Good afternoon, Josh.
It's always a pleasure to see you, and I hope all is well in the great state of New York. So we've had an exciting 2014, at least I have in a bunch of areas. I'd like your take on what you've seen, because I understand that you've attended two conferences recently. And could you tell our listeners what conferences you attended? And to avoid a compound question, what did you learn at those conferences?
Well, the two most recent conferences that I attended were last week, or right before Thanksgiving, actually. I was at the 11th annual Advanced eDiscovery Institute, Georgetown CLE. And then several weeks prior to that, I was at the National Association of Women Lawyers annual national meeting.
What struck you about the conferences?
Well, the advanced CLE at Georgetown was specifically focused on eDiscovery. The National Association of Women Lawyers meeting was in general for in-house counsel for women. Probably about a third of the attendees were litigators, so the issues were somewhat different. So I was focused in general on the litigation issues.
So let's break down each one. What litigation issues were important and front and center at the first conference?
So the National Association of Women Lawyers was some of the people who were attending there were assistant general counsels or general counsel focused in the litigation area. So they're looking from a management standpoint. How do they, as inside counsel, manage their myriad discovery across multiple outside law firms, process, procedure, what systems that they think they can manage inside, what should they delegate outside, how does one delegate it, how does one follow up in delegating it, since there's been a big, a lot of focus over the last year or two on attorney competence, and in fact that ultimately the buck stops with the within house counsel, regardless of how it's delegated out.
I agree, and a lot of that sounds like project management, which we've discussed before. Let's switch to Georgetown, and I haven't been, but I do know many of the people who go and who have presented at it, and I was looking at some of the tweets that were coming out, especially from the judges panel. What could you share about Georgetown that was memorable, and what did you learn, and anything else of interest?
Well, I thought it was a very interesting conference. Every year it's different. Sometimes there's sort of the buzz of the new thing. I don't think there was any buzz of the new thing this year. I think the judges were really focused on, to some degree, on what are the potential implications when the amendments to the Federal Rules of Civil Procedure are if in fact they're implemented as they've now been approved later in 2015. But in fact, really the issues about how practitioners should be addressing discovery issues. There was a lot of focus on where technology has gone, where it has not gone. I think that was the real delta for me. Some of the predictions from a year ago that vast amounts of electronic information across all sizes of cases and firms would now be done with some kind of a magic wand of analytics just simply has not panned out very quickly.
That's happened many times with discussions of technology and then reality being two different things. Like radio was supposed to eliminate classrooms in the 1910s. So no surprise there. Anything else jump out at you from the discussions on what people thought was important and timely?
Well, again, the same concept. The other big issue, which has been played around in the federal courts for the last few years, encouraged by the judges, is cooperation. And the idea being that you can be a zealous advocate for your client and still be cooperative. And in fact, by being cooperative, you can find the information more readily that you need, not spend a lot of time and waste a lot of money for your clients in motion practice around issues that could be resolved just by communicating between counsel.
Now, thinking big picture, looking back to Legal Tech 2014, and now when we're in December of 2014, what were some of the big trends that you have seen since you work with litigators daily in the world of document review and electronic discovery? What have you seen?
Well, I think the biggest trend is that there hasn't been a huge trend over the past year. I think there's been a slow trend, but the slow trend is it's important that we do it correctly. The data sets are getting larger and more complex. The requirements for speed and getting matters reviewed and through the system have only accelerated. And so there's a real emphasis on process and on getting it right and on reducing the data sets to the most responsive information. And so while there were all sorts of predictions a year ago that we were going to be rapidly moving into an era where you were just going to throw some either random or machine active learning data sets into a computer, and you were going to arrive at this small subset of highly very high precision and very high recall, just with a few swipes of your hand, has just simply not materialized.
When people say that sort of thing, I love pointing out the Thomas Edison quote where he said, "Books will soon be obsolete because of film." And people are still reading, and they might be reading on tablets now more than printed books, but we're still reading. Not that videos aren't a great way to convey educational topics, but there's always that pronunciation of this is what the future will be and how great it will be, and then reality. We still don't have hoverboards. So there's a lot of that. Do you have any thoughts on what we'll see in 15?
Well, I think, as I said, I don't think there was a flood of people moving towards using more technology-enhanced searching and review, but it's clearly moving in that direction, and I think we're going to continue to see it move in that direction. Just it's going to be 2 yards at a time, and I think that people have to get comfortable with basic concepts beyond just keyword searching and starting to use more advanced analytics, and get comfortable that in fact in the right scenarios and situations it can give you a less expensive and highly defensible process and review. I don't think that's going to change. I just think that you need more attorneys having more experience, feeling comfortable with this type of these kinds of technologies. And it's just, you still have attorneys that come out of the paper era that are just very uncomfortable with the whole process and concerned about it's not just that it's defensible, but in fact missing material relevant information. And so it's going to take it's going to be a learning process, and I think basically that behavioral change eventually is going to move into attitudinal change. It's just a slower process than I think a lot of people predicted.
Yeah, I do think there's been one positive thing across this year, and that I think in cases that I've seen, there's been a higher degree of attorney competency and judicial competency and jumping into the issues more, such as proportionality and being more granular and arguing the value of the information to the case. So I see that as a positive, but I don't see it as an earth-shattering change that you didn't have a giant De Silva Moore proportionality type case that everyone talked about. But there were a handful that showed proportionality and judicial understanding of it, and attorneys being able to argue it were more common this past year.
Yeah, and I happen to agree with that. But as one of the discussions at the judges panel at the Georgetown event highlighted, that proportionality, and which is now going to become more relevant because it's going to be moved up into the main section of Rule 26. It's still on a case-by-case scenario, because, often, yes, you want to prevent discovery abuses where somebody says, give me all and any, and they're basically looking just to harass the other side with searching through every, document out of terabytes and terabytes of data. On the other hand, you have other scenarios where you might have a discrimination case or an employment case or something where you're looking for some kind of relief for secrets or something else. Or civil rights movement actions or movements that have nothing to do with, per se, a dollar value. And so what's proportional then? And so there's a lot of, it's not clear. Two major corporations that are going at it, on a patent dispute, that's a different issue than somebody that's looking for relief from, some kind of a personal issue.
I'd agree with that, and I do think courts are getting better at it. And because the lawyers are understanding it more. That being said, there's still a lot of work to be done, especially in understanding how the technology can help attorneys, and especially on the project management side of things, and also in having effective meet and confers. So with that, is there anything else you would like to share of that you thought was big across 14?
Well, I think the other thing I heard, was listening to a lot of the practitioners in these last two events, is that there seems to be a real diminution of client support and project management in a lot of situations that wasn't there before, maybe attributable to the fact that the size of the raw data set sizes have become more complex. The time frames have become compressed. The unit pricing has become compressed. And so I think it's very difficult for people that don't have really strong workflow and systems in place in order to do the work and deliver a quality result. And as a result of that, sometimes you're just cutting back in the one area which we think is critical, which is having a very strong level of project management client support. And I've heard that lament quite a number of times in the past 6 months. So I find that very interesting.
Yeah, that's not good, because that goes to competency and being able to do things in an efficient manner so you don't miss anything, so you can either find responsive discovery or do the reasonable inquiry necessary to validate your case and to prove your arguments. That's scary. That is really...
and both of the conferences, when we were talking about the in-house counsel, that said, attorney competency, not just your professional competency, but of course your responsibility to make sure that not only your outside counsel, but the outside counsel's firms or vendors that they delegate to, in fact, have the requisite competency and skill sets to do what you need to do in the time frame you need to do it. And in fact, if they don't, ultimately, you're responsible. That was a key discussion in both of the conferences in the last month that I was at.
I'm glad to hear that there's that recognition, because the service provider is supposed to be the trusted partner that you work with. Everyone within the firm and within the corporate legal department should know what they're doing. And if you don't understand something, because not every lawyer who does personal injury from, say, a traumatic brain injury understands all facets of how the human brain works, but their expert does. And the same can be said with electronic discovery. Where's the data? How do you find it? How do you then collect it in a defensible manner? How do you process it? How do you review it? All of that's technical. There aren't magic discovery gnomes that just make that happen.
No. And competencies are just in terms of just capabilities.
Mm-hmm.
You have a deadline, and the deadline is missed. You can't just say, well, whoops, or they said it was going to be done on time. And so I'm hearing more and more of that. So it's interesting. That I think is one of the changes. That's not so much just technology. It's just about core competency and people being able to perform at a level. The speed of the ball is moving faster and faster now.
I would agree with that. Well, Howard, I appreciate your thoughts, and I look forward to doing a part 2 with Planet Data in the very near future about some of the new technology you have. So for all the listeners, stay tuned, because there will be more. And That will be the teaser for our next Planet Data special with some of their new technology that they have. So with that, Howard, I really want to thank you for your time. And any closing thoughts on 2014?
No, I think we're going to see a continuation of the trends we saw for 15. We're going to see a continuation of the trends we saw in 14. It should be a very interesting year going forward, and especially with the implementation of the new federal rules at the end of the year.
Fantastic. Well, everyone, thank you for tuning in, and stay tuned for more.